My Lord, have you had the opportunity of reading the Justice Abdullahi case?
Yeah, I have.
Without refreshing your memory, can I proceed to pick your thoughts on that judgment? If you need to refresh your memory, fine, I will stay away from it. But if you are so clear with the judgment, I may want to tease your view on aspect of it.
Honorable Chair.
Honorable members, we need to operate within the rules. This is a judgment delivered by the Supreme Court, properly constituted. Here is a nominee before us, asking him his thought on a judgment delivered by the Supreme Court, which is binding. I do not think we are fair to the witness in the circumstances.
Chairman, you are taking your powers too far. We are here conducting this exercise. We've had nominees expressing views on judgment, expressing views on judicial pronouncement. How then the nominee says he's read that judgment? I'm asking a question within a certain context. I need to pick his views on it. It doesn't mean he's going to condemn the judgment or he's going to question it. Then if you are ruling us out of order this way, then why are we here, Chairman?
Well, take a cue. A question was posed to Justice Sir Dennis.
Oh, Jesus.
And he indicated that once the Supreme Court has delivered a judgment, that is the decision of the judgment.
No, please.
The word he uses, whom am I to comment on that particular decision? That was what the judge said. It's a similar thing that you are.
I think that we need to situate some of these things in proper context. What my Lord Dennis J. said was misconstrued by you with the greatest respect. He understood the question to mean that he having to overrule that. And then he said, oh, that is the decision of the court. Who am I? He didn't continue. And I understood that to mean that, yes, when the court has ruled, it is binding. And I went further to say that the recent Kowasefua case, I had my own disagreement. But in the spirit of that principle of yielding in obedience to a court decision, I had to even rely on the majority decision led by my Lord Kulendi to make my case on the floor of the House. I moved away from that to then ask him his view. If judges come before us and they cannot express their view on a matter, we are not saying that they should sit here and overrule. That is not what we're saying. A judgment is binding on you, but you can express a view. And don't forget that the same Dennis A.J. talked about the end-all interpretation, where he believed that a particular panel interpreted the end in a manner. And when that panel was out, a new judge, a new panel led by the all group gave a new ruling, and that was it. So please, I don't want us to be having back and forth on the matter. So I only ask, can I finish, Chairman? Chairman, you would say what you want to say. Please, bear with me, with respect. I am not locking up the nominee's neck in any hole. I ask, my Lord, have you read the Justice Abdullahi case, which is relevant to my question? The article I quoted, he said yes. And I said, my Lord, if you can proceed to answer questions without refreshing your memory. If he says that he would need to refresh his memory, we move. Because if the man has read and he doesn't have the judgment with him here, I cannot ask an opinion. That does not mean that I'm asking him that a judgment which is binding on him, he should come and condemn it. That is not the gravamen of the question. So please, Chairman,
well,
let's get exercise right.